Hi, and welcome to Holland Estates. I'm Paul Trudelle.
And I'm Jonathon Kappy.
And you're listening to episode number 530. How are you, Jonathon?
I'm good. How are you doing?
Very good, thanks.
I can't think of a time where we've podcasted together.
I think this is our first time. We'll have to check the archives there.
We'll have to look back on the website, hollandhall.com.
So we're podcasting today, and I guess the question is, are you ready for a cultural shift?
That's what appears to be on the horizon. And we are talking about courts of probate and how courts of probate differ from normal civil litigation.
Right.
Civil litigation is adversarial. Every side takes a position and argues it in front of a court, and a decision is made. But probate is different. Deciding whether to probate a last will and testament, the court assumes a different role, and that is inquisitorial in nature. Mostly because the decision to grant probate doesn't just bind the parties to the litigation, it binds the world. It's an in rem decision. It governs how this estate is administered worldwide.
Right.
And also, the courts have an obligation to a testator who prepared this last will and testament and who is no longer there to speak for what their intention was in distributing the assets of their estate. And so the court also protects those interests. So it's not just about the parties.
Right, and for that reason, when there was a challenge to a will, it was usually quite easy to get the court to agree that proof in solemn form is required, and any interested party, just by objecting, would have a very easy time in getting the will challenge started, and the court would be very concerned as to whether the will was valid or not, and would allow the parties to explore that.
Right, so I just want to clarify for people who are listening may not know the distinction is there's two ways you can have a will probated. You can do so in a summary fashion, which is a normal application for probate. You submit it with your application and an affidavit and the will. You file it with the court,
Right.
and the court sends you back a stamped certificate of appointment.
Right.
But where someone requires a higher level of proof, you can be required to prove it in solemn form, which is a full-on hearing about the will.
And the court will then need to be satisfied with respect to capacity and due execution and the lack of undue influence and the like, and that is the higher standard.
Right.
Until recently, it was easy to require that someone probating a will prove it in solemn form. If you're an interested party and you had a concern about whether it was validly executed or whether the person had capacity, you would file a notice of objection. The next step would be an order giving directions that allows you to get access to the medical notes and records, lawyers' notes and records,
Right.
Examine witnesses, and then proceed to hearing.
There's almost a no-brainer at that point. You file your objection, and this is down the road
Right.
you go.
And the parties show up at court for the first hearing with an order giving directions that sets out all of these procedures, and the court would sign that, and off you go with your will challenge. The cultural shift that we alluded to is referred to in the decision of Seepa and Seepa, which is a decision of Mr. Justice Myers of the Superior Court of Justice, and it was released on September 11th, 2017. And it talks about the fact that orders for giving directions were usually routinely given, and seems to put the brakes on that.
Right, well, he's not happy with the status quo. He's not happy that anyone who just says, I object to the probating of a will, can now put the brakes on the administration of estate, put the estate through huge expense, litigation costs. And, he talks about, a testator's, expectation of confidentiality with respect to the legal file, confidentiality with respect to medical records, and how a testator wouldn't want people going through medical records after they're gone.
And how proof in solemn form is expensive, timely, invasive,
Right.
and the court has an obligation to the testator to ensure that their wishes are upheld and that there isn't this very invasive procedure started without something more.
Right. So Justice Myers picks up from where Justice Scalia's left off in Neuberger and says, hold on a second, is that really the way we should be going? Is it time for a culture shift? Should we be letting people go down this road and giving them these tools of discovery and all those other kind of tools in normal litigation,
Right.
without at least getting over an initial hurdle?
That's right, and that's what this court seems to cement or put into formality, is there is this minimal evidence required in order to be allowed to proceed with your will challenge. Mr. Myers acknowledges that it's not easy for someone on the outside, an excluded son, for example, to know what's gone on, to know what method of capacity was, to know what undue influence issues were there. However, you have to have something more than just a suspicion or
And that's just an allegation.
an allegation, which is where what you usually were allowed to begin with before.
Right.
You have to have a minimal evidentiary meet a minimal evidentiary burden in order to be allowed to start with your will challenge. The respondent is allowed to try to answer those concerns or questions, and if the respondent does rationally answer those objections so that the court isn't concerned, it may be that the court challenge isn't able to proceed, so
Right.
it doesn't get on the rails.
And I think that's what's important also that Justice Myers stresses. They talk about a minimal evidentiary threshold, and if you can put forward some evidence to raise some doubt as to a testamentary instrument, that's not where it ends. I mean, then the proponent of the will is allowed to, answer that question, right. And if that is properly answered, then the application can be dismissed. Both in Neuberger and Justice Myers highlight that in this inquisitorial court, the court controls its own process, and the court can decide how best to determine the testator's intentions and whether this will should be probated or not.
Right, and whether there is a rational, some reason for looking into or going on with the invasive inquiry of proof in solemn form. And you have to show the court or give the court reason why they should be looking more closely at this will. Another aspect of the decision is that once you get over that initial threshold, the court won't just give you the off-the-shelf order-giving directions, full-blown order-giving directions. And Justice Myers states that the court has an obligation to tailor the inquiry or the process to meet the needs of the parties and the nature of the objections.
Yeah, it sounds like the court is going to be a lot more involved in determining the process.
Right.
And not just allow the parties to run rampant and run up costs.
Right, and Justice Myers says that in certain cases it may be appropriate to have a case conference at an early stage, mediation before things get any further. Talks about maybe an all-hands meeting with the lawyer who drafted the will in this particular case in order to determine, well, what was said, what inquiries did he make with respect to capacity.
That was an interesting idea that he had. It's not something that judges ordinarily do, and it's more of a case management type involvement in the process. But saying, you've got these questions, why don't we sit down, we'll get the drafting lawyer's file on the table, we'll go through it, we'll have the drafting lawyer there with law pro counsel, he was very clear about that, and let's just figure out whether we can come to an understanding as to what happened. That's
right, before we get onto this lengthy formal process, let's see if we can work things out beforehand, or if there are concerns, address those at an early stage.
Yeah, and in this particular case, and obviously the facts of this case are absolutely irrelevant to the analysis of what's going on, but Justice Myers said that that's what he would have done, but for one fact. And the fact is that the respondent who was propounding the will, who was the son who was inheriting the entire estate, consented to the order-giving directions and all these powers that were in the order-giving directions, but more importantly that the applicant offered to pay for all the inquiries, to pay to find the records, the medical records, the legal records, so that the estate was not being unduly burdened by this inquiry that was being made.
I think we may see more of that, where the court will say, okay, you've met the minimal evidentiary threshold to question this will, but if you do want to proceed, you're going to pay the costs at the initial stage anyway, or subject to maybe a further order of the court.
Yeah, and I think that's been a long time coming. I think that we initially saw the shift with costs. Costs were originally just payable by the estate, and then it became more of a winner pays. Let's not saddle the estate with all these costs.
Right.
And now we're seeing a shift more towards, well, even the interim steps as we go along. Why should the estate be bearing all these costs?
That's right. If you want to play, you have to pay.
That's right.
So we'll put a link to the decision on our webpage, and I think it's must reading for estate litigators and those contemplating a will challenge or responding to a will challenge at an early stage. Until next time, thank you for listening. I'm Paul Trudelle.
I'm Jonathon Kappy.